Okay, our next case is Paulson versus Dixie County Emergency Medical Services. Mr. McCabe.
Sir, may it please the court, my name is Bill McCabe. I represent the claimant Michael Paulson, and I'd like to reserve 2 minutes for rebuttal. In this case, the judge of compensation claims denied this claimant workers' compensation benefits for an otherwise compensable June 17, 2001 accident because of misrepresentations the claimant made in regard to a prior April 7, 2000 accident. The judge reached this conclusion even though the judge specifically found the claimant did not make any misrepresentations concerning the June 17, 2001 accident, and the June 17, 2001 accident is the only accident the claimant was seeking benefits for in this case.
If you've been receiving benefits for both, would your argument be different?
Beg your pardon?
If he was receiving benefits for both cases, the one that the judge found that he was deceptive in and the one where the judge found that he wasn't deceptive, if he was receiving benefits for both cases at the same time, would your argument be the same?
It would be the same. It might be weaker, but it would be the same. Because, the crux of the argument is that if you make misrepresentations as to a prior accident, it should not forever foreclose you from receiving workers' compensation benefits for any future accident, and that's exactly what the judge's order in this case amounts to. This is a case of first impression. There's no case that I could find, or I don't think that counsel could find, that's discussed this particular issue. And I do submit that this is a pure question of law. And when I say that, I mean it. Neither side is challenging any factual findings in this particular case. We're not. The employer carrier isn't. There's no cross appeal. And I think that's important, and I usually don't like to discuss the facts of the case, but the operative findings of the judge of compensation claims in this case is that the claimant had 3 accidents with his employer. The first one was February 16, 1999. The judge said it has no effect on his decision. The second accident was April 7, 2000. And although the claimant did not assert any benefits for that accident, the judge found that it was relevant to this case. The third accident is the one for which the claimant is seeking benefits. That happened on June 17, 2001, when claimant sat in a chair which collapsed, causing injuries primarily to his right knee. Now, the carrier alleges at trial, and they allege in their answer brief, all kinds of purported misrepresentations that this claimant made. But the fact of the matter is the judge found one, and that was the situation concerning surveillance on May 17, 2000, which is almost a year, actually a little more than a year before the June 17, 2001 accident, when surveillance showed the claimant basically running a concession stand at some kind of festival while he was collecting temporary total disability benefits for the April 7, 2000 accident. As it relates to the June 17, 2001 accident, the judge specifically found the claimant did not make any misrepresentations. The judge rejected the carrier's contention that the claimant didn't have an accident at all. He rejected the employer carrier's assertion that the claimant didn't accurately account the various work accidents he was involved in. He rejected the employer carrier's assertions that claimant did not accurately recount the details of his multiple work injuries, etc. Now, with these factual findings, the judge addressed the issue as follows. He says the first question to be addressed is a legal one. Whether the claimant's misrepresentations concerning an accident in 2000, which is not the subject of the current claim for benefits, should be considered in support of the misrepresentation defense asserted for the 2001 accident. The judge found that it was. We submit that it shouldn't be. Now, I've read 440.094 and 440.105.4b. I know the statute has been interpreted quite strongly against claimants. It appears the interpretations of this statute are, even if the claimant does a seemingly minor misrepresentation for the purpose of securing workers' compensation benefits, he loses them all, irregardless of how severe the injury.
Mr. McCabe, isn't it pretty safe to say that there's not anything in our decisional law and there's nothing in the text of these relevant statutory provisions that leads us in a clear direction one way or the other in this case.
Well, there's no case law. I agree with that. Now, as far as the statute is concerned, where in the statute does it say that if the claimant violates this statute, he may never recover workers' compensation benefits again?
Well, we would be led to a clear answer if the statute said that. My point is the statute doesn't say that.
No.
And it also doesn't say the converse, clearly. I mean, it's just, isn't it really just silent on this situation?
Well, it doesn't say it. I agree with that completely. But can a judge add words to a statute? Can you add the words to that statute that says if you violate this one time over here, you're never going to get workers' compensation benefits?
Well, it does use the word like any, which would...
But isn't that what it amounts to? I mean, if he can't get benefits for a June 17th, 2001 accident, when the judge makes a finding that there was no material misrepresentations as it relates to that accident, because of material misrepresentations made in an April 7th or an April 7th, 2000 accident, isn't that the net result?
Well, I think Judge Allen's question is, in reality, the statutory language would support that result. I mean, if you make any misrepresentation to obtain any benefits under Chapter 440, then you waive all benefits under Chapter 440. I mean, you could get there through the statute, could you not?
Your Honor, the judge of compensation claims got there, so I guess you could.
Well, counsel, is it your position that the statute is silent on this issue? Is that your position?
My position is the statute doesn't say that you're forever barred from workers' compensation benefits. My position is also, the closest I could relate this to is a perjury, the perjury statute. I mean, because that's really what it amounts to. It's perjury. It's somebody lying for trying to get something. I found an old Florida Supreme Court case, Rader versus State, which is cited in the brief. It's a 1951 case, but it says, for perjury, it says, in order to sustain a conviction for perjury, not only must the substance of the alleged false testimony be proven, but it must also be proven that such testimony was material to the issue upon which the trial was had. And I cite a couple of insurance cases where a party makes a misrepresentation. One of them was a homeowner's insurance case. It was one I had way back in the day.
That's just the materiality element of the elements of perjury that's involved in that case, isn't it? I mean, you always have a materiality element in a perjury prosecution unless you have a particular perjury statute that excuses that.
You do have a materiality, but the reason I mentioned this Florida Supreme Court case is it says to the issue upon which the trial was had. Well, the trial was had in the case, our case, for the June 17th, 2001 accident, not the April 7th, 2000 accident. I also, I'd like to, if the statute's interpreted the way the judge did interpret it, then that does need to be known to people, because I don't know, if a claimant knows.
Well, that would be a good thing for a roofer to know, wouldn't it? Because if he was in the roofing business, all he'd have to do is look around and find some people who could hang shingles, who had gotten in trouble under this statute before, and he could save a lot of money on comp premiums, couldn't he?
You know, the example I have here on my little sheet is about a roofer. I'm glad we're at least on the same
I mean, their comp premiums are pretty high. He could probably undercut a lot of people on his bids when he goes out and tries to get a job.
Well, he possibly could. I mean, the point I was going to make, I was actually doing it from the roofer's standpoint, too. I don't know if a roofer would want to continue doing that kind of a dangerous job. If he knows if he slips and falls off the roof, he's not going to get any workers' compensation benefits. Similarly, the employer needs to know it, because the employer wouldn't have to pay workers' comp premiums, and the carrier certainly better not collect them.
Well, he's not excused from paying workers' comp premiums.
He could probably get a good rate, though, couldn't he?
Well, he shouldn't have to pay them at all, because he'd never have to pay comp benefits for that roofer. I mean, so why should he have to pay them?
I mean, his experience mod would be down.
I can't imagine that the legislature intended that result, yet that's the result that really would amount, that would stem from this case. So I'll reserve the rest of my time for rebuttal. Thank you.
Thank you. We'll reserve your time.
Good morning. May it please the court, my name is Lamar Oxford. I'm here for Dixie County in the Florida League of Cities.
And is it really Dixie County's position that if the roofer at age 18 makes some misrepresentation in a workers' comp case, he's forever barred for the rest of his life from ever getting any workers' comp benefits?
Definitely not. And I think this court will ultimately find a case in which it can educate everybody in the state what it thinks about how expansive this anti-fraud legislation is. I'm here to tell you this morning that this is not that case at all. If a man lies in a recorded statement in 1980 on a knee injury to one employer, and then 25 years later he's working for a different employer and he hurts his head, I don't think the legislature intended him to be penalized 25 years later for a mistake he made in 1980 involving a completely different part of the body and a completely different employer.
Now, we'd have to be really adding a lot of words to the statute to construe it that way, wouldn't we?
Well, you would have to be interpreting it. But you know as well as I know, as well as Mr. McCabe knows, that the legislature used the words, any misstatement, any fraud, for the purpose of getting any benefit.
Well, counsel, so you would draw the line at 25 years and a different employer?
Yes, sir. That's just an example. I agree. It's not for me to write any bright line test. It would be difficult. And maybe what Mr. McCabe is really asking for in this appeal and what the court is struggling with is a change in the legislation.
Mr. Oxford, I have to disagree with you. The statute does refer to any of the acts described in 440-105, but it doesn't refer to any workers' compensation benefits. The any doesn't modify the workers' compensation benefits.
I'm reading 105-4B1, the last two lines, for the purpose of obtaining or denying any benefit or payment under this chapter.
I'm reading 440-094.
Okay, now I am too. And obviously, we both know that those two statutes have to work together. It's my understanding, I think, that 09 gives the judge the authority to deny benefits to anyone who violates 105.
Right.
And it's 105 that says in its first sentence, to knowingly make or cause to be made any false, fraudulent, or misleading oral or written statement for the purpose of obtaining or denying any benefit.
I mean, Dixie County didn't even ask for this, did they? I mean, didn't you kind of go in there and say, this guy, look, he lied here, he lied here, he lied here, and we're telling you, Judge, when that chair fell, he made that up and he was lying there, and therefore you should deny benefits because he lied in this case, and the only reason that you introduced the evidence of the other cases was to show that he's a liar. Isn't that, I mean, you didn't even ask for this result, did you?
Lie after lie after lie after lie.
But the judge...
21 lawsuits in 20 years for disability claims. 9 workers' compensation claims, all of which he denied. I mean, this record is unbelievable. It's 2,500 pages
Well, maybe
long.
another judge would have found that he was deceitful in this case, but the fact that this judge didn't, that's what you're really asking the JCC to do, is to find that he had lied in this case, wasn't it?
Well, yes, and this case is inextricably intertwined. There's that phrase we heard earlier today. This guy had 3 accidents with us in less than 2 years, in about 2 years, including one right after he goes to work for us, and then as soon as he heals, one a year later.
He didn't make the chair claim right away. He waited on the chair claim. I mean, he was hoping he could get over that one.
Actually, I may be sticking myself in it here, but Mr. McCabe is, who I think the world of, is hoist on his own petard a little bit. He says that the standard of review for you gentlemen is de novo. And unless I'm mistaken, de novo means you look at the facts fresh. You weigh the evidence. We personally think on our side that this is a classic case of the tipsy coach.
Well, we can't go back and make fact findings about whether or not he was deceitful in this case, can we?
De novo? You can review the evidence in a fresh light. We presented undisputed proof that this guy was lying, left and right. It wasn't like the JCC here was weighing a lot of evidence. This guy admitted, oh yeah, I forgot about that. Oh yeah, I forgot about this. Oh yeah, I forgot about this. And somehow the JCC concluded that he had a faulty memory. I would tell this court that you don't forget 21 lawsuits and claims in the last 20 years.
Well, Judge Ullman thought perhaps he did.
It crossed our mind that the JCC was inviting the court to reverse, that he was really hurting us in this case, because he made fact findings that we thought were preposterous under the record. And I don't mean to do any disrespect. What I mean is, it was virtually undisputed that this guy was lying, left and right, for 21 years in the judicial system, constantly. And yet the JCC was buying this and buying that, and finally saying, well, I'm going to deny compensability because of one particular lie. Now, again, no disrespect, but it was as if he was setting us up for a reversal. But this case has horrendous facts. Bad facts make bad law. You're going to have a case.
But you don't have a cross appeal.
Why do I need one? I mean, I won on compensability. He says it's de novo. I can come before you and say, well, you can weigh the evidence.
Well, you can't do that unless you present a cross appeal to say that there was an absence of competent substantial evidence for the findings of the judge made.
Well,
now, obviously, this is a de novo determination on construction of the statute, but I don't see any challenge by either side to anything about the factual findings of the judge.
In my answer brief, I tried to point out, while we agree with the judge's conclusion that we think the facts were overwhelming and in many parts undisputed about this particular gentleman's fraud. That's all. And given the broad language of the legislature, any fraud or misrepresentation for the purpose of getting any benefit, we think this is a classic case for the statute to apply. And we think, even though it's your job to decide, you line up every legislator that voted for this law and you tell them the facts in this case. We think that they would purely and surely intend for the statute to apply to this case. The IME doctor, I mean, in a sense, Mr. McCabe is trying a technical argument. Yeah, he may have lied about this, he may have lied about that and all that, but he didn't lie about this particular thing, so the statute shouldn't have applied. Well, the IME doctor for the knee, for the injury from this accident said, I can't believe the guy. Once he was shown all the proof of like 8 knee surgeries, none of which he ever admitted to this doctor. And that's a minor example of a tremendous multitude of lies of this particular gentleman. He has abused the insurance system.
Mr. Oxford, instead of continuing to talk about the facts, which I understand your position, but you have to understand that I think you're absolutely wrong. I mean, if you're going to come in and challenge factual findings, you've got to take a cross appeal. And you didn't do that. But now let's look directly at the language of the statute here, and what is there other than this any and 105 before workers' compensation benefits that would lead us clearly to the conclusion that the judge was right in applying this statute, these statutes as he did?
Well, I apparently disagree with you and Mr. McCabe. I think the use of the word any in the very first sentence of how you violate the anti-fraud provisions is clear.
Well, now that's a subsection, though.
Well, that's the very first subsection.
Yeah, but other subsections that would seem to cover this don't have that language, do they?
I don't think you have to meet every one of them. I think these are examples that the legislature had given. In the very first one, to knowingly make any false statement to obtain any benefit. And, of course, it goes against us, too. If we lie or defraud the claimant, then we lose our defenses. So it works both ways. But
so it wouldn't be enough just to have B2 satisfied?
Wouldn't be enough. I think if you satisfied B2, then you would also have proven the fraud. Yes, sir.
Well, proof under B1 is sufficient, is your position?
Yes, sir.
Thank you.
But it's sufficient, but if you got proof under B2 coupled with 440.094, then that's a basis for the finding of the fraud defense.
You have an even stronger argument, yes, sir.
But we don't have the any requirement relating to any comp benefits under B2.
They use the word any in B1. They didn't use it in B2. I don't know if that's such a great distinction, Your Honor. I mean, they couldn't have been much broader than they were in B1. There's the legislative intent in a nutshell.
Okay.
Now, we understand that this court is looking for cases in which JCCs are overly interpreting these provisions. But it appears to us that the legislature surely intended it to apply to situations where the employer can prove that an employee like this is perpetrating fraud, not only in this claim, but in literally the last 2 decades of his life. And though there's not a case on point, this court said in the Rustic Lodge and Escobar case back in 1999 that forfeiture of benefits is not limited to the specific benefits that may have been obtained by fraud. While that case might not be directly on point factually, its legal principle should be directly on point here.
So, counsel, it's your position that any benefit means any benefit, not present benefits or past benefits, any benefit.
Yes, sir. And in this case, the claimant's own hearing statement going into trial, Mr. McCabe wasn't the trial attorney, his own hearing statement going into this trial listed all 3 of his accidents and listed multiple claims. So the technical argument that Mr. McCabe is doing a great job of trying to present as to his fraud not being specific enough to allow denial of claim here, we think flies in the face of the legislative intent. There's a tremendous amount of facts here demonstrating fraud. To reward this gentleman with an award of benefits would, we think, stand justice on its head. Thank you very much.
Okay, thank you, Mr. Thompson.
I think the argument that they made that if it's a lie 25 years ago, then the statute doesn't apply. I mean, that therein shows the difficulty, I think, with the judge's finding. And
But, counsel, if it was a lie 25 years ago for the purpose of obtaining benefits under Chapter 440, then it still wouldn't apply.
Well, the way the judge is ruling is it would, but I mean, they're saying it wouldn't now. Well, where in the statute does it say that? What we're asking in this appeal is that if a claimant makes a lie about a claim, then any benefits to which he's entitled under that date of accident, he shouldn't get. And B2, which we were talking about, I note says at the last sentence, it says, concerning any fact or thing material to such claim. Now, his misrepresentations and lies about the April 7, 2000 accident have nothing to do with his 2001 claim.
But, as Mr. Oxford points out, if B1 is satisfied, then that can carry the day for 440.09 sub 4, and that refers to any benefit or payment under this chapter. What we need to read that to mean any current benefit or current claim for benefit under this chapter.
I think it's got to be related to the particular date of accident.
He was not getting any benefits for the Red Belly Festival violation claim, correct?
He wasn't seeking any. And the judge says that in his order. And now, I will acknowledge that some of the earlier petitions, or I think even an earlier pretrial, did have all 3 dates of accident. But by the time they actually got to the hearing, the only benefits claimant was seeking was for the June 17, 2001 accident. It's so stated by the claimant at the commencement of the hearing on pages 2237 and 2238. The judge recognizes this is in his order on page 2218 and then again on 2219 and 2220. So it's only the June 17th 01 accident that he was seeking benefits. They go lie after lie after lie is what they say, but that's why I went over the facts at the beginning of this oral argument. I usually don't, but that's why I did, because the judge only found the misrepresentation as to the April 7, 2000 accident, not to the June 17, 2001 accident. As far as de novo review is concerned, it's because it's a pure question of law. Did the judge properly apply the law to the facts that he found in this case, which no one is challenging? We submit he did not.
If the claimant is receiving benefits under one accident, for an injury in one accident, and then subsequently has another accident and a separate claim, and then makes a misrepresentation as to that second claim, and it's established, what about the ongoing payment of the benefits for the first accident? Would those be cut off under the
I don't think they should, because his lie was about the second accident.
But you admitted earlier that that would be a closer question, correct?
It might be a closer question, and it might be closer if the body parts were the same. But, you know, in the April 7, 2000 accident, the body part's the left arm.
I mean, there really are three ways to look at this. One is a deceitful statement or a misleading statement at one point in time that is adjudicated as a deceitful statement bars workers' comp for all future whatever.
Right.
The second way would be that it only applies to the case that you're seeking benefits for. You have to lie in that case, and if you get caught, then you lose the benefits in that case. And the third way would be that if you are receiving benefits, as in Judge Allen's hypothetical, in more than one case at the time, and you're caught, it's like a bomb that goes off, and it stops everything at that point in time, and then you can go out, and if you're injured again, you get workers' compensation again, correct?
That's true. That could be done. My position is your second example. It's the accident that you're lying about that you no longer get benefits for, but not any other accident.
But that's really not the situation that we have before us in this case, though, right?
Yes, it is.
Well, I mean, I thought in this case we have a previous case that he was not seeking benefits for.
That he's not seeking benefits for, but that he lied about.
Right. I mean, was he receiving benefits in that case?
Yes, he did receive benefits in that case.
But was he currently at the time that he committed the JCC found he committed his deception in this case?
I don't think so. Because he had already reached MMI in that one, and he had gone back to work, and he'd already been paid out some permanent impairment benefits.
Then the chair broke.
Pardon me?
Then the chair broke.
Yes, sir. Thank you.
Thank you. Thank you both. All right, that completes our oral argument calendar for the morning. The court will be in recess.